Imagine you buy your absolute dream home. Like it sits right in the middle of the quiet, picturesque countryside.
Oh, that sounds perfect.
Right, you've got a wraparound porch, a completely unobstructed view of the rolling hills, and, for a while, everything is totally idyllic. It's the slice of paradise you worked your whole life for.
I can picture it.
But then, one day, you wake up to the sound of heavy machinery. Um, your neighbors have decided to lease their expansive acreage to construct this massive, glaringly industrial commercial solar array right next door.
Wow. Yeah, that would be a shock.
Overnight, it just completely ruins your beautiful rural view. And the real kicker, suddenly no one wants to buy your house. The equity you spent years building up is just, well, it's gone.
It really is a devastating scenario, and I mean, it immediately sparks a very visceral reaction.
Exactly. It makes you furious. So it raises this massive real-world legal problem for you.
Yeah.
Can you sue your neighbor simply because their property has become incredibly ugly and crashed your property value?
It's a great question.
Today, we are taking a deep dive into the doctrine of private nuisance under Vermont law. We're going to examine whether aesthetic displeasure and property devaluation actually satisfy the elements of a nuisance claim.
Right, and to do that, we will walk through the landmark 2017 Vermont Supreme Court case, Myrick v. Peck Electric.
Which is fascinating.
It really is. We'll unpack the distinction between emotional distress and property use, and then conclude with a synthesized, step-by-step diagnostic checklist. You can actually use this for exam taking or legal issue spotting.
Welcome to the deep dive. So let's start with a baseline concept here. What exactly constitutes a private nuisance?
Well, the general rule is that a private nuisance springs from the duty to make reasonable use of one's own property without occasioning unnecessary damage to a neighbor.
Okay, so making reasonable use.
Exactly. The black-letter rule requires an interference with the use and enjoyment of another's property that meets two distinct elements. It must be both, first, unreasonable, and second, substantial.
Got it. Unreasonable and substantial. So let's analyze Myrick v. Peck Electric. First, what are the legally dispositive facts?
Right, so the facts here are that a group of landowners in New Haven, Vermont, sued two solar energy companies. Their neighbors had leased property to these companies to build these large commercial solar arrays. And the plaintiffs claimed the arrays constituted a private nuisance because they destroyed the surrounding area's rural aesthetic and caused nearby properties to lose value.
Okay, and what was the core legal issue?
The issue is this. Does Vermont law recognize a private nuisance cause of action based solely on aesthetic considerations or diminution in property value?
That is the million-dollar question. What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
Sure. Relying on a 120-year-old precedent called Woodstock Burial Ground Asna v. Hager, the court applied the rule that the mere unsightliness of a thing does not render it a nuisance.
Wow, a 120-year-old rule.
Yeah, it goes way back. To prove a nuisance, a plaintiff must satisfy three elements. First, harm to the actual present use of the land. Second, substantial interference. And third, unreasonable interference.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, harm, to the actual present use of the land?
Okay, so the sub-issue here is whether looking at something ugly impairs a property's physical condition or use.
Right.
The sub-rule is that freedom from emotional distress is distinct from freedom from annoyance in the actual use of land.
Which means what, exactly?
Well, the court applied this by distinguishing between, say, a solar panel reflecting glaring light into a neighbor's bedroom, which physically interferes with the use of sleeping, versus a panel that is just visually unattractive.
Ah.
Because the plaintiffs only suffered emotional distress from the appearance, the court concluded this first element was absolutely not met.
Understood. Now, what about the second element, substantial interference?
Right, so here the sub-issue is whether an unattractive site meets the threshold of definite offensiveness, inconvenience, or annoyance to the normal person in the community.
And I assume the plaintiffs felt it was definitely offensive.
Oh, absolutely. But the court applied the facts by noting that the mere appearance of the neighbor's solar arrays does not physically prevent the plaintiffs from walking on, building on, or occupying their own land.
Right, they can still walk around their yard.
Exactly. Therefore, the court concluded the interference was not legally substantial.
Understood. Now, what about the third element, unreasonable interference?
Well, the sub-issue here is whether aesthetic complaints can even be measured by the unreasonableness standard.
Which is tricky, right?
Very. The sub-rule is that nuisance claims must be quantifiable. like noise, vibration, or odor. You can measure those.
But you can't measure ugly.
Precisely. The court reasoned that aesthetics are inherently subjective. One neighbor might hate solar panels, while another equally reasonable person finds them beautifully modern. Because these preferences cannot be quantified, the court concluded this third element could not be met either.
And after analyzing all the elements, what was the court's final conclusion?
The court affirmed summary judgment for the solar companies. Synthesizing the elements, aesthetic harm alone fails to establish an unreasonable or substantial interference with the actual use of property.
So it just fails completely.
Yes, it fails as a matter of law.
Okay, I hear you, but I want to test the absolute limits of this rule with a hypothetical.
Okay, let's hear it.
Suppose my neighbor paints their house neon green and covers the lawn with giant, anatomically correct, rotting flesh gargoyles.
Oh, wow. That is quite the image.
Right. It is so viscerally gross that I physically gag every time I look out my window.
Yeah.
Does that change the analysis? I mean, I'm having a physical reaction.
It's a great hypothetical, but honestly, here's the brutal reality of the rule. Even though it provokes a physical reaction, it is still purely visual.
Wait, really? Even the gagging doesn't count?
Nope. Unless the gargoyles emit a quantifiable odor, vibrate the ground, or shine neon lights directly into your living room, the law classifies your gagging as emotional distress.
That is wild.
It is. It's not an impairment of your land's present use. The aesthetic rules stand strong no matter how gross the gargoyles are.
Why is the law so incredibly strict here?
It's really about policy context. If courts recognized aesthetic nuisances, judges would essentially become arbitrary arbiters of style or taste.
Right, like the government deciding what art is.
Exactly, leading to inexorable confusion, and it would create this converse mischief. Neighbors could block any construction they simply found ugly. Aesthetic control really must be left to the legislature through zoning laws or restrictive covenants.
Not tort law.
Exactly, not tort law.
Okay, so if we can't win on aesthetics, we have to follow the money. The plaintiffs in Myrick also argued that the solar arrays demonstrably lowered their property values.
Yes, they did.
Does a direct hit to your wallet change the court's calculus?
It actually doesn't. The general rule is that a decrease in market value does not, on its own, mean there is a nuisance.
Just losing the money isn't enough.
Right. Diminution in value is merely a measure of damages for a nuisance that has already been otherwise proven.
Okay, let's look at the precedent they tried to use for this. Let's analyze Allen v. UniFirst Corp., which the plaintiffs relied heavily upon. First, what are the legally dispositive facts?
So in UniFirst, state inspectors discovered a chemical solvent from a dry cleaner had entered Williamstown's drinking water.
Oh, wow, so actual contamination.
Yes. A group of homeowners sued, claiming widespread public fear of contamination caused a massive decline in their property values, even for homes not directly proven to be contaminated.
Okay, and what was the core legal issue?
The issue was, does diminished property value caused by adverse public perception alone constitute a private nuisance?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The rule is that diminished property value from public perception is only recoverable under a narrow exception. The rule requires two elements.
Okay, what are they?
First, an actual and substantial threat of physical interference like chemical contamination. And second, a resulting decrease in value causally linked to that specific generalized threat.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element? An actual and substantial threat of physical interference.
So the sub-issue is whether the solar panels in Myrick pose a threat comparable to the chemicals in UniFirst.
Which seems like a stretch.
It is a stretch. The court noted that in UniFirst, the harm wasn't just dropping property values, it was the actual physical threat of toxic drinking water.
Right, poison.
Exactly. Applying this to Myrick, the solar panels pose zero physical or chemical threat to the neighboring land. So the court concluded the first element was totally absent.
Understood. Now what about the second element, a resulting decrease in value, causally linked to the threat?
Well, because the plaintiffs failed the first element, meaning there was no underlying actual interference with the land's use, the court concluded the second element was moot.
Because you can't measure what isn't there.
Right. You cannot measure damages for an interference that doesn't exist.
And after analyzing all the elements, what was the court's final conclusion?
The Myrick court ruled that the plaintiff's interpretation of UniFirst was far too broad. Diminished property value without a requisite interference with the property's actual use fails to state a nuisance claim as a matter of law.
But wait, isn't that inherently unfair?
How so?
Well, if my neighbor's actions objectively cost me thousands of dollars in property equity, shouldn't tort law make me whole?
It sounds unfair until you look at the policy rationale. The court uses this palatial estate analogy. Property values fluctuate due to countless factors.
There are market trends, schools, things like that.
Right, so if the law allowed you to sue a neighbor for building an oddly shaped house that lowered your property value, the rule would have to be reciprocal.
Meaning what?
Meaning, imagine a neighbor builds a gorgeous palatial estate next door, and it significantly increases your property value.
Okay, I'd love that.
Sure, but logically, under that rule, they would have a claim to charge you for the boost they just gave your equity.
Oh, wow. I owe them money for building a nice house.
Exactly. To avoid endless neighborly discord and these weird one-sided rules, the law simply rejects value-based nuisance claims outright.
Okay, that actually makes perfect sense when you put it that way.
It does. And to help pull all of this together, I think we should synthesize the entire module into a diagnostic, step-by-step checklist. You can use this on exams or even in legal practice.
Yes, let's do that. What is step one?
Step one is to identify the nature of the complaint. Is the plaintiff complaining about a quantifiable physical intrusion like noise, light, vibration, or odor? Or is it just a subjective visual displeasure?
And if it's visual, they're out of luck.
Exactly. Then, step two, apply the actual present use element. You have to ask yourself, does this condition physically stop the plaintiff from occupying, building on, or utilizing their land?
All right, can they still sleep in their beds?
Yes. If it only causes emotional distress or annoyance, it completely fails.
Okay, what is step three?
Step three is to analyze unreasonableness and substantiality. Remember that unreasonableness requires an objective metric. Because aesthetics are inherently subjective, they fail the unreasonableness test.
You can't put a meter on a gargoyle.
Set property value claims. If the plaintiff claims lost property value, search the fact pattern for an underlying physical threat.
That's the UniFirst chemical exception.
Exactly. If the drop in value is purely due to neighborhood aesthetic preferences, it is not a nuisance. It is merely an unrecoverable damage.
Wow. So if nuisance law refuses to protect your home's aesthetic value, and the only real protection lies in rigid zoning laws or homeowner association covenants.
Which can be incredibly strict.
Very strict. It really raises an uncomfortable question for you, the listener, to mull over. Does owning property in modern society actually give you freedom, or are you just holding a temporary license strictly governed by your local zoning board's taste?
That is a great point to end on.
Thanks for joining us on this deep dive.